aviation labyrinth. Okay, so the recording is started now. Again, for those that are watching the recording, I just gave a very brief introduction to the topic of sustainable supply chains and why it is that I'm going to be talking about experiences from Germany and Europe, because in Germany, as of the 1st of January of this year, we have a supply chain act that's in force. And just recently, on the 14th of December, we had a press release that the trilogues have come to a provisional conclusion, that the Council of the EU, together with the European Parliament, have negotiated a provisional text that is now going into the ordinary legislative process. Now, starting off at the very beginning with what I've titled here a sustainable abbreviation labyrinth, I think it pays off to cover some of the words that are thrown around in the area of sustainability. It's a topic that obviously is very en vogue today, but of course also is therefore subject to much confusion and misuse. It's used as a marketing tool. Very often the terms are not fully or not properly understood. And so I'd like to give you a very brief introduction to what might seem a little bit overwhelming when one first comes across it. So obviously, what we're talking about is in the realm of so-called CSR, corporate social responsibility. And another abbreviation that you will often come across in relation to corporate social responsibility, sometimes even used synonymously and interchangeably, is ESG, meaning environmental, social, and governance. But while CSR describes the material, substantive application of responsibility in areas outside of the genuinely corporate realm, be it social, environmental, labor rights, etc. ESG is more of a quantitative criterion, as a measuring criterion, and is used primarily in what is referred to also as ESG reporting, which at the end of the day in the corporate sphere is nothing other than non-financial reporting. Now, in this area of non-financial reporting, we see a bunch of different proposals by the European Union already in force for quite some time. Is, for example, the NFRD, the Non-Financial Reporting Directive, which together with now SFDR, Sustainable Finance Disclosure Regulation, was basically the framework within which financial as a non-financial reporting took place within the European Union regulatory framework. And this is also, well, this is of course not an abbreviation, but just to guide you there, this is very strongly connected to the EU taxonomy, something that is also thrown around quite a bit, although very often not properly understood. The taxonomy is a system by which particularly financial products on capital markets get to call themselves, get to be labeled sustainable, and which criteria these need to comply. And this is particularly relevant for corporations that are public, where then the SFDR comes in. Now, we have a couple of proposals that are on the table or about to enter into force, namely the CSRD, the Corporate Sustainability Reporting Directive. And now you may have heard of this abbreviation or not, the CSDDD, or the CSDDD, as some refer to it, which is what I'm going to talk about today, namely the Corporate Sustainability Due Diligence Directive. So this is just to cover some of the somewhat admittedly confusing vocabulary and abbreviations that riddle this area of the law. Now, giving you an overview of what it is I want to talk about today is first the background of supply chain legislation. So to just give an overview, where does it come from? Where do we stand? What are the domestic initiatives so far, proposals? What do we have at the EU level? Then I'm going to talk about the question of which kind of norms that corporations need to comply with within these supply chain legislation frameworks. Primarily, these aren't obligations of result. These are obligations of conduct, due diligence norms, meaning that in the case of supply chain legislation, corporations need to apply a specific standard of care. And thirdly, sanctions, meaning what is the consequence of violation of any of these pieces of legislation. And then finally, towards the end, I'm going to provide a brief outlook. Now, I was asked by Dimitrios, who would have normally moderated, as far as I understood, to provide 60 minutes roughly of lecture and then open up for half an hour of question and answers. But to the audience, I would propose, if there is anything that's of interest to you, we can stop at any time and you can just raise your hand. I mean, I'm not always sure I will be able to keep everything in view, depending on whether you are raising a question in the chat or whether you're raising your hand here as a participant. If I overlook you, please just unmute yourself perhaps and give a shout out, and then I'll be very happy to try and explain whatever it is that your question might relate to. So starting off, I want to give a little bit of background first. What is supply chain legislation? Where does this come from? Particularly because supply chain legislation is very much event driven. So it's circumstance driven. We had, of course, numerous tragic events. I'm just picking out two very prominent ones that one might reference in this regard. We have, for example, in 2013, the Rana Plaza collapse in Bangladesh, where we have more than 1,000 people dead and 2,500 people injured, due to what basically was a construction error where, in fact, for the building, there had already been a notice of closure, that it was did not pass building inspection, that it had not been built to standard. And instead, the companies that were seated there, primarily companies in the textile industry, still encouraged and drove their employees to work. And on that fateful day in 2013, the building collapsed and the tragedy ensued. And now, why this came to such global attention, or at least European attention, was that within the European markets, there were multiple fast fashion labels and retail stores that had, in fact, in their supply chain, clothing that came from this exact building. And so at the end of the day, in Europe, consumers were buying products from factories that did not comply with basic labor rights, labor standards, and this is what triggered some of the supply chain debate that leads up to the German supply chain legislation, and then following that, the European supply chain legislation. And another such example you see on the right-hand side, there's a picture of Foxconn, famously one of the largest provider of parts to Apple products, like the iPhone, for example, that are produced by Foxconn. And here what you see, this seemingly innocent yellow fixture on the building's facade, those are so-called anti-jump nets, and they were installed to prevent employees from committing suicide due to the dreadful labor conditions that were there in these special economic zones in China, where Foxconn, a Taiwanese company, operated. And you may have also heard of the company due to the deteriorating conditions there, where workers were held during the hard lockdown in China. And of course, these are instances that bring the issues behind what is now supply chain legislation to the attention of a broader audience and to civil society. And this gets us right to the logic behind supply chain legislation. Now, the first assumption for supply chain legislation is that globalized supply chains rely on, obviously, different working conditions relating to hours, wages, health and safety regulations, rights, the phenomenon of modern slavery, of course, where people are working in conditions that are analogous to slavery. And of course, different human rights standards, environmental standards that apply across the globe. This is obviously a fact, a truism. But the question is how to deal with that. And the problem is, if you're dealing with companies, these can only be held responsible within their own domestic legal system. So, of course, for example, a state like Germany might, in the Human Rights Council, criticize China, might criticize other countries where such conditions aren't properly ameliorated, or where there is no movement or no betterment of the conditions. But at the end of the day, it's up to the state whether it reacts, how it reacts, depending also obviously on its human rights obligations, etc., etc. So at the end of the day, a state like Germany won't be able to hold accountable a Chinese corporation or these various textile companies that were seated in Rana Plaza. And this is now where the logic of supply chain steps in. At the end of the supply chain, in the market, you have financial leverage, either through specific contractual agreements that one might say force the companies along the supply chain to comply with these standards, or in the most extreme example, one could sever the business relations with the company that's violating those workers' rights, human rights, environmental standards. Now, obviously, the discussion on all of this, the discussion, one might say, on corporate social responsibility is not all that new. We already have, since way back the 1970s, the discussion on business and human rights. And some of you might be familiar with the OECD guidelines for multinational enterprises, which have been around since 1976 and have been reissued, updated throughout the years up until today. And the UN guiding principles on business and human rights, something that's perhaps a bit more novel. And of course, various companies, at times marketing, at times consumer driven, have implemented corporate social responsibility and non-financial reporting obligations on a voluntary basis, for example, also through company codes of conduct. Now, the thing with all of these is that they are what we call in international law soft law. So they are tools, not rules. They can be applied where they're found useful by a company, but there is not necessarily a legal obligation. Where we do see legal obligation, albeit only in a sectoral area, is the gradual inclusion of chapters on sustainability and human rights in investment and trade agreements. So in international economic law, which funnily enough is often criticized for doing the exact opposite, but more and more these treaties, particularly those negotiated by European Union member states or the trade agreements negotiated by the European Union, those include chapters on sustainability and human rights. And for example, if you know a little bit about trade relations, you will have heard perhaps about the dispute between the European Union and Korea regarding labor rights, where it was also said, well, this is a paper tiger, this is akin to soft law. But in fact, the European Union used the opportunity to criticize the labor legislation of Korea through instituting a panel where there was an investigation of the situation. The panel found indeed that Korea was in violation of its obligations under the trade agreement and indeed took domestic measures to ameliorate the situation. More and more now, while in international law, much of this is still in the realm of soft law, we see domestic implementation of supply chains. So one of the earliest instances is the Modern Slavery Act in the United Kingdom. We have the French Loi de Vigilance, which particularly includes a specific form of company liability. And we have in the Netherlands or Switzerland now various legislation and finally also in Germany and Norway, domestic legislative efforts that aim specifically on making these human rights standards, environmental standards, labor conditions obligatory upon corporations, at least by way of a due diligence obligation. And why it's so interesting to look at the German example is not because I'm teaching at a German university and happen to speak German and can translate the various provisions for you, but because it serves as a kind of a blueprint for what is happening at the European Union level. So it's very much similar to the EU proposal that we have seen, or the proposals that we have seen so far. And this leads me now also to talking a little bit about what is happening at the European Union level. Now, it's not necessarily a surprise that the EU is active in this area, although oftentimes one hears it said that the EU is here starting to legislate in areas that are none of its business, that it is overreaching, that it is unnecessarily restricting corporate freedom. And this is not necessarily surprising that it does that, because if we read already Article 3, paragraph 3 of the TEU in the version of the Treaty of Lisbon, we see in the second sentence, right after it said that the Union shall establish an internal market, that it shall work for the sustainable development of Europe. And what does sustainable development mean for the European Union? It means exactly what it means for the United Nations. The European Union always makes reference to the UN Sustainable Development Goals. The EU even says it itself took a pioneering position and role when the Agenda 2030 was negotiated and passed as a resolution of the General Assembly. And so when we hear sustainable development in the realm of the EU, what we have is the 17 Sustainable Development Goals. Now, this is not the only thing where the European Union references sustainable development. In the Treaty on the Functioning of the European Union, we find in Article 11 that environmental protection requirements must be integrated in the implementation of Union policies and activities, and particularly with a view to promoting sustainable development. And if we look further to the substantive provisions that we find, for example, in Article 191, paragraph 2 of the TFEU, it states in its first sentence that the Union policy on the environment shall aim at a very high level of protection. And secondly, and we see here referenced a number of principles of international environmental law, it says that this high level of protection is based, number one, on the precautionary principle, which we know is perhaps the highest standard of risk abatement, namely of taking into account the residual risk that we have in any process that is analyzed, including, of course, on which this precautionary principle is based, preventive action, and the two principles of environmental law, namely rectification at the source and the principle that the polluter should pay. The polluter pays principle, meaning that there should be an internalization of costs wherever there are companies, individuals that benefit from a certain activity that might be detrimental to the environment. Now, this is the background against which the European Union has now embarked on this legislative track to adopt supply chain legislation, namely the EU CSDDD. And we've been discussing this now for almost 2 years now, since in February of 2022, the EU Commission put forward its first proposal for such a directive. Perhaps a little bit surprising, I myself was among those that thought if there is a supply chain legislation at the EU level, it would be a regulation. But it turned out being a directive in the end. Why did I assume a regulation? Because obviously a regulation would be directly applicable and unify the law for all the member states. When you think about supply chains that always move across borders, the directive, of course, has the consequence that at the end of the day, we will have 27 different domestic pieces of legislation where companies will have to make themselves familiar what is required of them specifically in each domestic piece of legislation. We've had various steps along this legislative track, perhaps the less relevant ones portrayed here in a smaller font. We've had the Economic and Social Committee give its opinion on the text, but more importantly, perhaps, on 1st December of last year, the Council of the European Union issued its general approach. And there it rode back on a number of positions that the Commission had originally taken. And of course, as the process usually goes, when half a year later the European Parliament again issued its proposals for amendment, we see a number of issues that have been taken back by the Council. The Parliament wanted to include again, and not even that. It, of course, goes a little bit further. Now, we have again, on the 6th of June, the opinion of the European Central Bank, and up until recently, we could rely on the comparison of the various text proposals of the Commission, the Council, and the Parliament to discuss what the final outcome of this directive might be. So the trilogue, which is a kind of informal procedure in advance of the legislative process where the Parliament and the Council, under the purview of the Commission, which guides the negotiations, seeks to find a proposed agreement that then goes into the actual formal legislative process. We had the press release on the 14th of December, so just last week, that there was a provisional deal, although the text was not yet public up until the day of today's lecture. So unfortunately, I cannot tell you any more than what we've had so far. There are only the press release, a number of key points that have been highlighted, what will definitely be included in this provisional deal. Now, if there are no further questions from your side at this point, after this background and overview, I would move forward now to discuss what are these due diligence norms that are included in supply chain legislation, particularly in the European proposal, but what we already have similarly within the German Supply Chain Act. Now, what I'm referring to on these slides is always the text of the Council proposal. Why? Because in my view, the Council proposal is the baseline. And usually what happens in the trilogue when the European Parliament tries to negotiate further positions, usually the baseline is what the Council originally takes as a general approach. There might be adjustments here or there, but generally this would be what I'm showing you now, the most conservative approach to what the final text might be. Anyhow, we find in Article 4 defined what is meant by due diligence. And it says that member states shall ensure that companies conduct human rights and environmental due diligence as laid down in the following articles by carrying out a number of actions. So the obligation of conduct of the parties is laid out through a formalized procedural process. So what does this consist of? Number one, companies that fall within the scope of the directive, and in order to fall under the directive, you need to pass certain criteria, meaning a certain annual revenue that the company must generate depending on which industry the company is in. Then such companies need to integrate due diligence into their company policies and risk management system. So it means into the existing policies and into the existing risk management systems. Secondly, it's necessary to identify actual or potential adverse impacts in accordance with Article 6. I'm not going to reference this. We don't have time in the scope of this introductory lecture to go into detail on these different aspects. but it references basically the articles 5 to 11 where the detail is laid out. Thirdly, to prevent and mitigate potential adverse impacts and bring actual adverse impacts to an end and minimize their extent. So these are two aspects. Number one, prevent and mitigate where adverse impacts might arise. And secondly, where adverse impacts already exist, to bring these to an end, and where this is not possible, to minimize their extent. And here we see already one thing that is evident in the German Supply Chain Act, particularly as the administration explains the application of this Supply Chain Act. The idea is not for companies to end business relations with other companies along the supply chain in third states where there are violations of human rights or environmental norms. This is only the last resort. The idea is, under the due diligence obligation, to work with these companies towards bringing their conduct into compliance with the due diligence obligations. So the actual adverse impacts must not necessarily lead to a severance of the business relations, but if it's possible to minimize their extent, this should be the preferable way forward. The logic or rationale behind this obviously being that merely severing business relationships will not lead to a betterment of the situation in the third state. Now, fourthly, establishing and maintaining a complaints procedure. You have surely all heard of the term whistleblowing. The idea is to implement a procedure within the corporation by which employees might address adverse impacts, risks along the supply chain that they have already identified, that they have heard of, to bring a course of steps, to trigger a course of steps towards preventing, mitigating, and combating these adverse impacts. And this complaints procedure is very, very broad and should, on the one hand, be integrated into existing whistleblowing mechanisms, but also stretches beyond the corporation along up until employees of the supply chain companies. In addition, it's necessary to monitor the effectiveness of any due diligence policy and measures that have been taken. And finally, this is of course when talking to corporations, particularly those that feel they do not have the necessary capacity as it is, that all this goes hand in hand with the necessity to provide documentation. So all of these steps need to be documented and made to certain extents also public, not just in the non-financial reporting that a company might be obliged to follow, but also on a company's website, for example. Now, those of you that are familiar with business and human rights and have had any relation with the OECD guidelines that we already mentioned previously, this due diligence procedure laid out here in Article 4 of the directive will be very much familiar to you because it corresponds with what the OECD guidelines lay out. It's a continuous compliance procedure, a due diligence procedure. You see here, number one, embed responsible business conduct. This is the first step. Moving forward, one needs to identify and assess existing adverse impacts, where those are at risk or where they have already materialized. It's necessary to cease, prevent, or mitigate such adverse impacts. And then finally, to monitor and track the results of the steps, the measures that have been taken. Now, in the communication, how impacts are addressed, this is important, but at the same time, a bit of a friction with another phenomenon that the EU is trying to tackle, namely greenwashing, which consists of making broad claims as to the sustainability or human rights compliance of a certain product without really having taken steps. On the other hand, what the EU tries to do and what is already inherent in this OECD risk management procedure is to mainstream due diligence into the company's work, into legislation, wherever. And so there must be a communication to show what the company is actually doing. Moving forward, wherever appropriate, as a final step, cooperation in remediation, when appropriate, must be given to companies along the supply chain. And then again, the circle continues, starting again from steps 2, 3, 4, 5, and so on. So it's a continuous process. It's not an obligation of result, as I said. It's rather an obligation of conduct, or one could say an obligation of continuous results. One must always make sure that the wheel is moving, that it is going forward, that steps are being taken to better situations along the supply chain. Now, which norms are there in fact? This is just procedure. Which human rights, which environmental norms, which labor standards are there that we're looking at? And this is where it becomes particularly interesting from an international and domestic law relation perspective. Because the specific material, the substantive norms to which companies are held accountable, and this is similar both between the German Supply Chain Act and the EU directive proposal. In both, we have this regulatory approach of listing in annexes the various norms. And so we have here, for example, in part 1, human rights obligations of general nature and specific reference to human rights and fundamental freedoms instruments, meaning specifically international treaties, but also, interestingly, soft law norms. So the Universal Declaration of Human Rights might be referenced in the annex. We don't know for sure yet because we don't have a final proposal. And while the Commission and the Parliament have always made reference to the Universal Declaration of Human Rights, the Council's position was to rest the obligations on hard law, black letter law. And then in part 2 of the annex, we have environmental prohibitions and obligations. So just to give you a little bit of a picture of what this looks like, we might have, for example, in Annex 1, Part 1, the first section on human rights, paragraph 2, it says the right to life, including private or public security guards protecting the company's resources, facilities, or personnel, causing death of a person due to a lack of instruction or control by the company, interpreted in line with Article 6, paragraph 1 of the International Covenant on Civil and Political Rights. Now, this section of text already has quite a number of interesting aspects to it. So number one, who would have expected that the human rights obligations, such as the right to life, human rights obligations traditionally obviously being addressed to states as the bearer of obligation, whereas individuals or perhaps even companies are rights holders in the human rights system. Here suddenly, by way of a due diligence norm, companies need to ensure that along their supply chain, this human right is not breached. Which kind of constellations are relevant for the right to life? We see here already, for example, the reference to private or public security guards. So this is obviously a reference to very specific forms of industry that are resource intensive, mining operations, where you might have governmental security, you might have private security guards that commit such crimes against, for example, indigenous populations. But of course, there's nothing to say that not preventing conduct like the ones witnessed at Foxconn, for example, with their suicide anti-jump nets, well, that might fall within the definition. But how do we interpret the right to life? Now, the interesting aspect here is that it says, interpreted in line with Article 6 of the International Covenant on Civil and Political Rights. Now, from an EU perspective, you might have expected it to reference the Charter of Fundamental Rights of the EU, or perhaps the European Convention on Human Rights. My personal guess is that the reason is to not give it an all too Eurocentric flavor, rather choose a universal treaty, namely the International Covenant on Civil and Political Rights. But this still doesn't answer the question of who interprets and how. Because here, of course, we have treaty bodies that oftentimes give very progressive, wide interpretations of what the right to life includes, which might not correspond with the understanding of states. Secondly, the International Covenant on Civil and Political Rights is perhaps not a prime example because it's ratified by all member states of the European Union. But imagine another human rights treaty or environmental treaty that has not been ratified by each and every member state of the European Union. This means that now suddenly, through the back door, so to speak, a state has legislation that provides that corporations are bound to due diligence with regard to human rights, to which the state itself is not bound. So generally, what we know, apologies, I wanted to go to this slide, that's the correct slide. Traditionally in international law, we know the following incorporation techniques, namely transformation, where we have, you see here an image of the Austrian Federal Law Gazette, where the domestic laws are promulgated. And we take the international treaty, transform it into domestic law. In the case of adoption, we promulgate in the Federal Law Gazette that a certain international treaty is part or is binding within the legal order of a state. So transformation means making international law into domestic law. Adoption means pointing towards the international legal norm, thereby making it part of the domestic legal order. Now suddenly, with the supply chain legislation, we have the situation that we are incorporating norms that are not necessarily even binding for the state, have not been made binding within the domestic legal order, but now enter through EU law and enter there with an interpretation to which the state itself might not necessarily adhere, with the final word obviously resting where? Resting in Luxembourg with the European Court of Justice. So only once the European Court of Justice has in fact pronounced on a specific provision here will we know what it exactly entails. Now, just to give you a brief overview, what can we imagine what's in these annexes? We have, for example, a prohibition of torture, cruel, inhuman, and degrading treatment as per the Torture Convention. We have the right to liberty and security. We have the prohibition of arbitrary or unlawful interference with a person's privacy, family, home, or correspondence. The prohibition of interference with the freedom of thought, conscience, and religion, and the right to enjoy just and favorable conditions of work, just to name a few. And there, of course, these are not necessarily human rights which one might immediately associate with human rights that are relevant for a corporation. But think about a telecommunications company from the EU, from an EU member state, that operates in Belarus, for example. Obviously, very easily, you might come into the situation that there is an issue here with conducting your due diligence with regard to the prohibition of interference with privacy, family, home, or correspondence, as well as with the prohibition of the interference with the freedom of thought. Now, going further, I mentioned already, we have various treaties that are mentioned, the entire International Covenant on Civil and Political Rights, the entire International Covenant on Economic, Social, and Cultural Rights, and the International Labour Organization's core and fundamental conventions that are included as part of the due diligence process. When we come to environmental norms, for example, we have all kinds of prohibitions regarding to biological diversity, the CITES Treaty, the Convention, the International Trade of Endangered Species, or the Minamata Convention regarding mercury levels. Now, all of this suddenly now, through the directive and the directive's domestic implementation, will become part of the due diligence process that companies that fall within the supply chain legislation will have to follow through with. Additionally, the directive as we know it from the text version, the general approach of the Council, still includes a specific provision outside of the general due diligence provision, namely that states are also here obliged to ensure that certain companies adopt a plan, including implementing actions, as well as related financial and investment plans, to ensure that their business model and strategy are compatible with the transition to a sustainable economy. And not just that, but to limit global warming to 1.5 degrees in line with the Paris Agreement. And I'm not going to read the rest of the provision, but think about that, particularly in resource-intensive industries. This will be a huge burden upon corporations to establish how can the company's strategy move towards the 1.5 degree goal. And now, I'm sure many of you are familiar with the Paris Agreement. And then you will already think, why 1.5 degrees? You see, the European Union is striving beyond the 2 degrees that are laid out in the Paris Agreement, and they are referencing the 1.5 degrees aspirational goal. So it goes beyond and raises the scope. So this was to briefly explain the due diligence obligations and to give you an idea of the extent that these will have, and leads me now to my third part of the presentation, namely to talk about sanctions. Of course, if you have an immediate question, please do feel free. So if there's no immediate questions, let's talk a little bit about the consequences. What will happen to corporations that don't comply with supply chain legislation? Now, what the directive says, and interestingly, the text versions that we have so far aren't very specific on what the exact sanctions are, but they say imposition of effective, proportionate, and dissuasive penalties. Now, this is something that in the EU spectrum we know from antitrust, for example, from competition law, right? There, the idea of these huge fines that you often hear about against tech companies, etc., is to disincentivize them from engaging in such conduct in the first place, that it can under no circumstances be economically feasible to, so to speak, buy yourself out, to weigh is a violation of the legislation less costly than compliance. It's supposed to be dissuasive. In addition, and here we have a difference to the German Supply Chain Act, we have civil liability that is included. So civil liability regime, like in the Loi de Vigilance of France. And at the end of the day, all of this will be monitored and enforced by domestic authorities, and the claims for damages, of course, will be integrated into the framework of member states' legal systems. Now, looking at the specific provisions, what the penalties are, it says here in Article 20, paragraph 1, penalties including pecuniary penalties. And then at the end, as I've already cited, that need to be effective, proportionate, and dissuasive. Now, when it says including pecuniary penalties, this, of course, also insinuates that penalties are also perhaps non-pecuniary. And so we might ask ourselves, what might such non-pecuniary penalties look like? And we can look into the crystal ball of the German Supply Chain Act. And there, for example, we have a provision that excludes corporations that have violated the German Supply Chain Act from the award of public contracts entered into the competition register until sufficient remedies have been taken, or up to a maximum of 3 years have passed. So if you want to participate in public procurement proceedings in any competitive public tendering process, a violation of the Supply Chain Act might exclude you. And secondly, when we look to pecuniary penalties, currently in the German Supply Chain Act, but this will obviously have to be adjusted once the EU directive is here, it's currently between 100,000 and 8 million, or 2% of the annual global turnover. So that's, depending on your annual turnover, can be quite a substantive amount, in addition to skimming off any economic advantage. So meaning you won't just get the penalty, but if it's proven by the authorities that you've made an economic advantage, that you have gains due to the violation, those will also be skimmed off and will have to be paid back. And here in Germany, we have enforcement at the administrative level through the Federal Office for Economic Affairs and Export Control. Now, it says here also regarding the penalties that in addition, there might be targeted support with regards to the penalties, and that there shall be taken into account whether such investments have been made or targeted support has been provided along the supply chain, and this will be weighed in. Now, what does this mean? Small and medium enterprises, SMEs, will not be included in the scope of this directive. But if an SME is a business partner of a company where compliance is necessary, then here supporting this company in its compliance with the supply chain due diligence will perhaps reduce the penalties that are here imposed, thus already incentivizing companies to work together with their suppliers along the supply chain. Now, moving forward and looking at the power of the supervisory authorities, it means that any remedial action that a company has taken, although we have the reference to the targeted support, does not necessarily preclude the imposition of penalties from happening, lest even civil liability. Also, when pecuniary penalties are imposed, they shall be commensurate with the company's worldwide net turnover, as it says here in paragraph 3, which means we might well be guided by the German Supply Chain Act. Furthermore, Article 20, paragraph 4 states, and this is something that's also novel, not just for the purpose of public procurement proceedings, as in the German case, but generally there will be a naming and shaming registry where corporations that have violated due diligence obligations will be listed. The final slide I want to show you is that on civil liability in the version as we have it regarding the of the council, regarding the civil liability of the company and a right to full compensation by those that have suffered harm due to violation of due diligence. Now, the proposals of the Commission and of the Parliament also include direct liability of the CEO. This was struck out in the council version, but still we would have this text that member states should ensure in their domestic law that companies can be held liable for damage caused to a natural or legal person, provided that the company intentionally or negligently failed to comply with obligations laid down in Articles 7 and 8. If you remember to the due diligence provisions we looked at, these are specifically the taking measures against risks or already occurring adverse impacts. And that as a result of a failure, the damage to natural legal persons' legal interest was caused. However, A company cannot be held liable if the damage was caused only by its business partners in its chain of activities. It must be a direct link between the violation of due diligence by the company held liable and the person, natural or legal, that was injured. Now I'm coming towards the end of my time, towards the end of the 60 minutes that I was allocated, and I'd like to conclude with a brief outlook and perhaps discuss what are some of the challenges that companies will face in light of this. And I have some insight from the German market and already neighboring markets such as Austria, where companies are, of course, preparing, dealing with companies from Germany that are affected by the Supply Chain Act. In essence, we have a number of compliance challenges, meaning that you need to implement in your corporation and consider increasingly human rights and environmental due diligence with a basis in international treaties and EU law. This, of course, means getting legal expertise and know-how to understand these international treaties and EU law obligations, which can be a challenge, for not all corporate lawyers are necessarily knowledgeable in human rights and environmental obligations. We will see a very fragmented landscape, meaning different obligations depending on the European target market. Quite practical challenges. One speaks in supply chains of tier 1, tier 2, tier 3, depending how far the company is detached along the supply chain. And I was involved in exercises where we tried to portray supply chain processes up until the very end to the resource. And you see, number one, in the EU, moving away each tier, you will get a higher percentage of services or goods from third countries. In tier 3, this can already be as high as 2/3 of the entire service or good. And of course, at some point, it becomes very, very difficult to actually follow the supply chain up to its source. And of course, we don't know yet what practical tools might prove efficient. The EU speaks of websites, platforms, portals, perhaps those that are familiar with export processes, export numbers, as they're used in the Convention for the International Trade of Endangered Species, might be helpful, but so far there is no best practice. Now, in the draft, we find reference to voluntary model contract clauses the companies can take recourse to assist them in implementing the due diligence obligations, and that the Commission might also provide for accompanying measures such as dedicated websites, platforms, or portals, and particularly that small and medium enterprises burdened through corporations bound through this directive will manage to seek assistance from there. So possible measures for companies as of today are quite open. They include a number of due diligence steps to take before the supply chain legislative measures will be implemented. We need to probably look at a medium to long-term creation of sustainability compliance across the board based on sustainable development as understood by the EU, which means the SDGs, as an element of the business judgment rule. The business judgment rule, which usually in corporate parlance means financially, right? But it will include in the future for sure non-financial obligations. So this could happen through the development or update of company codes of conduct with regard to due diligence obligations, further training, although here you see there's kind of Wild West mentality of all kinds of service providers giving compliance manager training, although we don't necessarily know yet what the best practices might be. Know your customer, risk analysis along the supply chain, something that many law firms are already familiar with, particularly with regard to financial, to money laundering obligations. Update of general terms and conditions of corporations, specific contractual agreements, also regarding auditing obligations, and of course, the self-establishment of automation-supported portals. So to put this in a checklist, what should one be aware as this supply chain legislation increasingly becomes part of our regular legal landscape, our regulatory landscape? Which measures are in place in the company to ensure that they comply with minimum working conditions, human rights and environmental protection standards? Is there something in existence? Which departments in the company are already involved in existing measures? And what gaps can one identify going forward? How can existing company contracts and policies be adapted to address due diligence obligations along the supply chain? And what steps are planned to fulfill obligations from supply chain laws with regard to working conditions, human rights, and environmental protection standards? And finally, how can risks along the supply chain be better integrated into existing risk management? With that, I have almost used up all of my time, all of the 60 minutes. I thank you all for your attention and conclude. I'd be very happy if you have further questions to now enter into the discussion, into the Q&A. And beyond that, you can reach me. I'm currently guest professor at the University of Trier, but I'm still reachable under my address at the University of Passau, where I work as an associate professor at the chair of constitutional administrative law at public international law, European and international economic law. Thank you so much, and looking forward to the discussion. And with that, I'll end my screen sharing.
Are there any questions?
I'm checking the chat. Don't see anything there, but
No, I don't think so.
well, it's late in the day. I don't know if you have any questions. Otherwise, perhaps you can digest my presentation, and obviously also please just reach out to me, but I obviously stand available.
Thank you, Professor Markus.
Thank you very much. Good evening.
Okay, so then it's goodbye. Thank you so much. Thanks for moderating, and have nice holidays and a good start to the new year. So with that.
Nice holidays, Professor. Thank you.